So, continuing on our series of answering some frequently asked questions, we're going to move on to one of the biggest, which is, please explain to me what deliberate deprivation of assets is. And I'll gladly do that right now. Deliberate deprivation of assets is where an individual has, for the sole purpose of avoiding care home fees, disposed of an asset, and that asset would usually be a home. The easiest way of someone doing that is either to give it away or to actually transfer it into the name of a loved one, a son or a daughter, for example, and in some cases transferring it into a trust. Now, what is important to understand is that transferring a property into trust in its own right is not in itself deliberate deprivation of assets. It is deliberate deprivation of assets if it is done for the sole and overriding reason of depriving the local authority from having their money and obviously using your property to pay for your care fees. But it is not deliberate deprivation of assets if you've transferred the property for valid reasons other than that. So, good examples of valid reasons to transfer your property into a trust. Well, the first thing we need to consider is, before you even consider going to do this, before you consider putting your property into trust, you must answer no to the following question. Have you been diagnosed by any medical practitioner that you have a degenerative condition or chronic condition that would give you reason to believe that going forward you may need to go into care? Because if the answer is yes, you can't do it. That would be deliberate deprivation of assets. So if you're already receiving help for arthritis, for example, you've already been given a diagnosis for dementia or Alzheimer's, that's not going to work. It would be deliberate deprivation of assets, and we can't help you. However, if the answer is no, or you are a couple where one party can answer no, then we can help you. Effectively, you need to be considering the reasons why you want to be doing it. Now, the first one we've touched on, funnily enough, in our a broadcast on wills, when we talked about protected property life interest trusts. And in this case, we'll be looking at a probate trust, a property probate trust. That would actually give a partner a life interest in the property. So, for example, you could transfer your property from joint tenants to tenants in common, transfer both halves into a trust right now, and this would be done for the reason to prevent, should one party pass away and the survivor remarry, sideways disinheritance. This is where, if we weren't looking at a trust situation, a surviving spouse would inherit a property and could remarry, then subsequently die, and the new spouse take all of that property, and then when they die it be given to their children, and the original children of the marriage get nothing at all. That's called sideways disinheritance. So reason number one, right up there at the top, is to prevent sideways disinheritance, to protect your property or your share of the property should your partner remarry. Similarly, and a lot of people don't realise this, that any property that is actually in a property probate trust doesn't need to go through probate. It's not part of the estate anymore. So it actually cuts down on probate fees, it cuts down on obviously the cost and the time in exacting the estate upon death, and of course means that the beneficiaries get that estate, or that part of the estate, the property that's in the trust, immediately. So there are some very good reasons for doing it for that as well. Now, if you use loan notes, now I won't go too much into loan notes in this broadcast because I will have another blog on this in the future, but if you use loan notes when you're appointing money or assets to beneficiaries, then that actually prevents them themselves from losing what they've inherited from you via a divorce or bankruptcy or even inheritance tax or going into care themselves. So if you have a trust and the trustees appoint the assets out correctly using loan notes, it will have the effect of generationally preventing further inheritance tax. So this is a very good reason for doing it as well. So there are a number of reasons why an individual or indeed a couple could wish to place their property in trust. I'll give a very good example for a single person, for example. So let's say a party at 50 years old has gone through a divorce. Within that divorce settlement, they've received the property and they're living in that property with their children. They don't want to be prevented from remarrying, but similarly, if they do remarry, they don't want to be in a position, should they divorce or indeed subsequently die, to lose the property, which obviously is the children's home, stroke their inheritance. So they would put in place a property probate trust to prevent that happening. Now going forwards, if they reach the age of 80 or 90 years old and then needed to go into care, their property couldn't be used to fund their care because they had placed their property in trust at a time when they could not have perceived going into care was a possibility, and for reasons other than depriving the local authority from using the property to pay for their care. So if you come and speak with us, we will dispel all the myths around deliberate deprivation of assets. We will tell you what the law is, we'll tell you how to abide by the law, and we'll also tell you how our trusts work, which is effectively because we put in the trust all of the reasons why you've set the trust up in the first place, so that going forwards, if you were to lose mental capacity and be the only survivor of the relationship, even if you couldn't speak for yourself at that stage, it would be very clear in the trust why you've done that. So usually come along and have a chat to us by coming to the shop, 46 Goring Road, or give us a call on 01903 649 021, and you'll find a heck of a lot of information on our website, which can be found at www.thywill.co.uk.